Good morning, everyone. My name is Alex and I'm the municipal clerk. I'll be calling this meeting to order. Welcome to our Court of Revision hearing. I would like to do a motion to appoint the chair. Could I please have someone nominate themselves to sit as the chair of the Court of Revision?
Yes, as a matter of fact, Lady Acting Clerk, I will nominate myself.
Excellent. Thank you.
Councillor Greenfield.
So I will just need a seconder for appointing Councillor Greenfield. Thank you, Deputy Mayor. All in favor? Thank you.
Thank you again. Any disclosure of pecuniary interest before we begin the meeting? If something should arise later on, feel free to mention that. And Alex, you will tell us a little bit why we're here this morning concerning the Mitchell Henry Municipal Drain. Go ahead.
Thank you, Mr. Chair. So I'm just going to speak to the Court of Revision jurisdiction this morning. The Court of Revision is an appeal body established under the Drainage Act that allows landowners to challenge their drainage assessments. The Court of Revision has one power to reallocate funds in a drainage assessment schedule. The court may hear appeals on 3 grounds. Land or road has been assessed too high or too low. Land or road should have been assessed but has not. Due consideration has not been given to the land's use. The court only has the authority to change the schedule of assessments. They cannot make changes to the technical aspects of the report, and they cannot refer the report back to the engineer for modifications. Although the Drainage Act requires the owner to give notice of appeal at least 10 days prior to the first sitting of the Court of Revision, the court may pass a resolution at the first sitting to accept verbal appeals at that time. When considering assessment changes, the court must consider that total cost of the project must remain the same, which means that if the court reduces an assessment, the court reallocates the shortfall among other assessed property owners. And if the court is considering adding to the assessment of one or more properties whose owners are not in attendance, the court must adjourn and send notice to assessed property owners who were not at the Court of Revision at the time of the reallocation. This allows the reassessed landowners to appeal their new assessments.
Thank you, Alex. We'll move into number 5 on our agenda. It's the engineer's report, and RJ Burnside Engineering has been involved with this project right from the early days. So, in accordance with Section 55 of the Drainage Act, in any appeal to the Court of Revision or to the tribunal in which the engineer is called upon to give evidence as to how an assessment was determined, the engineer shall give evidence before the appellant's case is presented. Reading of the appeal received. I'll go ahead with that. Court of Revision has received an appeal from Frank Robert Lipset. Subject property is 599236 Second Concession North, Anna, Ontario. Mr. Lipset pleads that the proposed drainage works, known as the Mitchell Henry Municipal Drain 2024, is not within the boundary of the watershed. Mr. Lipset further pleads that the tile contractor and landowner of the subject property originally started tile work on his property without his permission in or around January, February of 2022. Had this not occurred, the current situation and drainage works may not be necessary. In short, he pleads he is being assessed to repair and correct a drainage issue caused by a neighbor. Mr. Lipset will be called to speak to his appeal shortly. Before we do that, we will get an explanation on the overall assessment from the engineers, and we do have Jeremy Taylor, project engineer from RJ Burnside and Associates, here to provide an explanation on the assessment. Mr. Taylor, can you please join us?
Yes, thank you, Councillor. So I will, my presentation is to go through and present the assessments and the logic that we put together for this report and this drain. I'm going to first refer to the drawings that are located in the report in Appendix G, and hopefully Alex can put them up on the screen here for you. So we're going to look at the watershed plan as we talk through a number of these items, and then I have an assessment sheet that I'll hand out and talk in detail how we went about distributing the cost for this drain, which was $182,000. So this is the drawing that is in the report under Appendix G if you're looking on your own screen, but on the ones up above. So in the top of the drawing is the plan view. It shows the aerial location of the drain. And there's other drawings within the report. We're going to just focus on the plan view. The bottom part of this screen is showing the profile of it. So on the left side of the screen where you see the blue line, that is where the drain is going to be installed. And it is located on 502636 Ontario Limited, or which I refer to as Mr. Davenport's property. He's the owner. So the tile that's being installed is located on his property. It's about 575 meters in length. It's going to start at the left side, which is at the Waterton Creek, and then it extends along the fence line, or just offset of the fence line on Mr. Davenport's property, up to the corner of our petitioner, which is Mitchell Henry, which is shown as 7-071 or lot 28 in concession 3. At the upstream end of this blue line, we're going to be installing a ditch inlet catch basin. And that will be the point where Mr. Henry will have the access to connect his under drainage tile. And we'll also have a opening on the top of the catch basin where surface water will also get into the drain at this point. There's noted there's a dark black line with dashes around the outside of Mr. Henry's property, which is on the right side of the screen here. That dark line is what we put together as the proposed watershed that's going to be draining into this tile drain. We went to show the conditions. We didn't show the existing conditions or the watershed boundary for the existing condition of what is flowing across the lands. Instead, we focused in on what would be entering that tile with that watershed boundary. You'll notice on Mr. Henry's property, there's a hatched area, the lines that are drawn on an angle in there. And that's an area that is outside of the watershed. It tends to drain surface-wise to the south, and that gray line towards Side Road 27. And Mr. Henry has indicated that through his tile contractor, that area is going to be under-drained into the watershed. So we accounted it into the area calc that I'll explain later for outlet. You'll notice that there's a small portion on the right side of Mr. Lipsett's property, which is on the top of the page, on the north side. Mr. Lipsett, who's the appellant, has two properties here, one in concession 3 and one in concession 4. The east one is concession 3, is where the barnyard area is. And that small little area, we've determined that the surface water does drain south and into Mr. Henry's property. So that's why we've drawn the line around his property in that area. There's a few light gray lines that are on the left side of the screen. And you can see them kind of angling in a north and west direction. The Waterton Creek is labeled that way at the end of the blue line, but there's also a number of gray lines shown on Mr. Lipsett's property. Currently, there's a channel that runs north-south along the Davenport Henry line. I presume everybody's okay with the names rather than trying to say that Ontario Limited number all the time. So it's runs north-south, and it's a ditch that's been created along the Davenport and Henry line. There's also a second gray line that's running underneath the blue line, and that runs from the corner of Mr. Henry's property along Mr. Davenport's property and then turns on a 45 or so and then runs into Mr. Lipsett's property. It's an existing channel. The water tends to flow in this area from an east to west direction and then also north as well, so a northwest direction. As I mentioned, we didn't show the natural channel or the existing watershed boundary. We just focused in on what area we'd be getting into that ditch inlet catch basin as part of this report. You'll notice in Mr. Lipsett's property, there's also a couple other gray lines in the bush area. During our site visits, we noticed that there was a number of low runs and areas in that were collecting and routing water through the area. So to start the explanation of our assessments, because you just had the training, it ties in well, but when we look at our assessments, we split based on the Drainage Act between benefit and outlet. So section 22 and 23 of the Act. It was just read out to you, but benefit basically under section 22 of the Act for benefit assessment is lands, roads, buildings, or other structures that are increased in value or more easily maintained. And then the second way that we look at assessments or split assessments based on the Drainage Act is for outlet. And we just had the definition read to you, so I won't go through it in detail, but basically the outlet portion, we're looking at the volume and rate and flow of water. As it is mentioned in your training recently, there is also the outlet and injuring liability. We've combined them in our report, so it is just one assessment for outlet. When we do our assessments, drainage engineers in Ontario generally use with something that's called the Todgen method. It's been developed back in the late 1960s. And what the method was meant to do was to take that split that was in the Drainage Act and figure out a method to go between splitting benefit and outlet that's under the Drainage Act. So for this report, what we've looked at splitting the benefit to outlet is about a 30% of the cost of the drain as benefit and 70% to outlet. That's our first number. So I've got a sheet and I'll walk through it in a bit here to explain how we break down those numbers. The other thing to note with this drain that we looked at was the current conditions. So when we arrived at the on-site meeting and then put together the drain and the proposal that we have here, we noted right from the start that the landowners in this area, there was definitely some concern between the landowners, and that we quickly realized that there's definitely more than one side to the story. What we looked at, and as Sid mentioned earlier in the training, is our job as engineers is not to look at assessing past blame, or penalizing others, or trying to figure out who did what to when and how. What we're faced with is we've provided a drainage solution, this blue line that's going to take some under drainage as well as surface water down to Waterton Creek, and a fair assessment of how the cost for that drainage project that we have proposed should be assessed to the landowners in the area. Through our process, we had several options that we discussed with the landowners after our on-site meeting, and we put together some preliminary designs. As we mentioned, the current flow of surface water for the outlet of these lands is generally east to west, and then it heads north as well. The water collects on Mr. Henry's property, and it makes its way across to a channel that, to our opinion, was dug well before our on-site meeting. This channel runs west along Davenport's and then continues north into Concession 4 into Mr. Lipsett's property, where it eventually gets to a natural outlet. One option that we considered at the onset was to deepen and extend this channel to keep the water going on its current path. The direction we got back from landowners, including Mr. Lipsett, was that he didn't want this to occur. He wanted the water to be diverted elsewhere and not through his land. The option 2 that we had presented to landowners was what's in front of us today, which is that blue line. Putting all the water into a tile drain for Mr. Henry's tile outlet that he needs, as well as some surface water. We're putting a berm up at the catch basin that's going to be at Mr. Henry's property, so water that's flowing overland will be allowed to berm and collect at that area and get into the catch basin. But we have limitations on how big we can make the tile, so at some point surface water will exceed what capacity that tile can take, and it'll continue to flow overland downstream as it does today. As a result of all this work, what we felt as we went through this, that there is a perceived positive benefit to Mr. Davenport and to Mr. Lipsett, the downstream landowners. The new municipal drain will collect some of the surface water that's flowing naturally overland, and it will also provide an under drainage outlet to Mr. Henry's property and his intention to tile the area. When we look back at the section 22 benefit assessment, benefit is actually defined in the Drainage Act. It's, and Sid had read that out earlier as well, but it's a means the advantages of any lands, roads, buildings, or other structures that come from the construction, improvement, repair, maintenance of works that result in either a higher market value, increased crop production, improved appearance, or, and this is one I want to highlight, a better control of surface or subsurface water, or any other advantages relating to the betterment of land. The key point, I think, in that definition for this drain that we're looking at when we're assessing benefit to the downstream landowners of Mr. Davenport and Mr. Lipset is that we have control of surface and subsurface water. It's a better control system than what we have in place now. Please, the court, I'm going to hand out the detail assessment sheets that we created for this property. So I'll give you a copy as well. So this sheet we do for all our municipal drains. It's called a sectional assessment worksheet. I'm going to work you through from top to bottom on the numbers and how we come up and splitting the cost between the landowners for this drain. So at the very top is the yellow highlighted is 182,000. And that's the total cost that we have to assess for this drainage project. The first box down called specific costs. That's an area where we look at anything that's directly a benefit to one of the landowners. So for this drain, we looked at the proposed filling of the existing channel on Mr. Davenport's as a direct benefit to his property. So once this tile is installed along the property line, that channel that exists in Mr. Davenport's field will be filled in and it'll become more of a swale, which he'll be able to get returned to working agriculturally. I've also assessed 50% of the DICB, which is the ditch inlet catch basin, which is at the property line between him and Mr. Henry. And I've also assessed half the cost of the berm to Mr. Davenport as well, because I feel that the water is directly onto his property affected first. We also have engineering and a min that's assessed out as part of this construction. So that is a ratio based on the total cost of the drain. And so adding all those numbers up, we assess that directly to Mr. Davenport. On Mr. Henry's property, we gave him half of the ditch inlet catch basin directly. And reasoning for that was that he needs a direct connection for his tile drainage that he's putting on his property. And then we put the ratio of engineering and a min to him as well. So we start with this 182,000. We take some specific costs and assess them to some of the lands in the watershed. And then we subtract that to get a number that's called the remainder to assess, which is 164,800. So now that we have this 164,800, we need to find a balance between benefit and outlet for the property. As I mentioned earlier, we chose a split of 30% benefit, 70% outlet to upstream lands. We felt that the downstream lands are going to be benefiting by that control of surface and subsurface water. We didn't feel that all the cost, 100% of this, should be going as outlet to upstream. Likewise, we didn't feel that a large percentage of the cost should be as benefit to downstream, i.e. 50% or more. So we chose a number of 30% for that split. So if we can scroll up the sheet a little bit. So we have 164,800. We're going to take 30% and assess it as benefit. So that box number 5 there, it says remaining for normal benefit is $49,440. So for benefiting properties, we felt that the benefiting properties are the two downstream properties of Mr. Davenport and Mr. Lipset, and we split it 50-50 between the two of them. And that's basically $24,720 to each property. We felt that that balance was fair to each of the properties, one not benefiting more than the other, since the control of surface water is affecting both their properties. We had already assessed Mr. Davenport some additional costs that were directly on his land with the filling of the channel and that berm that's right next to his property line. The remainder to assess is under outlet, which is section 23 of the act. And that's that 115,360 that's highlighted there. As mentioned earlier, we had a small portion of Mr. Lipset's property, the upstream end, about a hectare or 1.2 hectares that we felt flows surface water into the area. That's an outlet. Section 23, if you recall, was to be assessed out on a factor of rate and flow of water. So for Mr. Lipset's upstream property, what we use for factors is one is an agricultural land area. Forested area, as mentioned earlier, was a 0.5 factor. If we had roads, we'd probably be factoring the land up by 4 or 5 times the area. For Mr. Lipset's upstream property, we felt that because he doesn't have a direct connection, a small little area, and other means to get under drainage for his property, we factored that area by 0.5, meaning that we're only taking into account the surface water coming into the watershed. His under drainage, if he chooses to do that in the future, will not come into this drain. Therefore, we don't think he should be assessed at a full rate of 1, that some of the other lands that Mr. Henry's are. Conversely, if you recall from the drawing of that area that was hatched that's going to be under drained into the watershed of Mr. Henry's, we factored that at a factor of 0.5 as well. So under drainage in was 0.5 or under drainage out at 0.5. So when we apply those factors, we add up the equivalent area that's upstream, and we divide that into the 115,360, we get $1 per hectare rate for our outlet. And then take that $1 per hectare and multiply it by their equivalent area. And that's how we come to the final numbers for outlet. If you scroll up on the box a little bit on the screen, you'll see them in the middle at the bottom there for Mr. Henry's of 112,000, and then Mr. Lipsett's for 2,380. And that's basically how we went through the process, splitting up using the Drainage Act of benefit to outlet, looking at the watershed and looking at all the landowners in it and how they were affected, using the tools that are in the Drainage Act and the definitions provided, and dividing the cost up in that matter. Based on our experience, we feel that there is still benefit to downstream landowners. There is an improvement to the control of surface and subsurface water. There's also a need for outlet that needs to be assessed in this portion as well. For the petitioner that is looking to do some under drainage, needs that tile outlet. I think that's all I have to present at this time. I'll take any questions if there is any from the Quarter Revision. Now,
Thank you,
everything
Mr.
else we got.
Taylor. Much appreciated. Councilor Uri or Deputy Mayor Keaveney, do you have any questions for Mr. Taylor at this time? Okay, I do have, I think it's a fairly simple one. If you can go back to the map, am I correct in saying that the entirety of the underground drainage, when it is dispersed, will run onto Mr. Lipsett's property, the concession 4 property of Mr. Lipsett?
Correct.
I'm sorry?
Sorry, your question was the under drainage water?
Yeah.
So any tile water right now?
And basically, will the under drainage stop? The under drainage piping stop at that point? And when the water is dispersed over Mr. Lipsett's property, is that above grade? Or is I'm thinking there is no continuous tiling on the Lipsett property.
Correct.
Okay.
Yeah,
So
the current tiles that outlet, and there's a photo of it in the report, are in Mr. Henry's property at the corner in a channel that's been dug in the past.
okay.
And then it flows in this channel and that gray line, it's in that gray line that's underneath the blue and then into Mr. Lipsett's property.
Okay, I just wanted to get that.
Yep.
Get that confirmed in my mind. Thank you.
Yeah, that's our understanding. Yep.
If there are no further questions for Jeremy, number 6 on our agenda has to do with appeals, the appeals that have been presented, and we do have the one, and that is from Mr. Ron Lipsett, and at this time I'll call upon Mr. Lipsett to speak about his appeal, and if you would come to the podium, Rob, and welcome. Go ahead.
Thank you. Thanks for the opportunity as well. And I've enjoyed this learning experience much like you have. I don't think I need to remind everybody this is precedent setting for our municipality. And the deeper I've dug into this, the more I realize I actually have a job that I've got to protect people in the future here so that they don't have to go through what I've gone through. And I've now gained an understanding of how we got to here through Burnsides and their assessments. And I understand they've had to come in and look at a situation and provide a solution for that situation. But my problem has started far before Burnsides and Associates were ever contracted. The easiest thing for me to do is go back to the start. In the spring of 2021, the Davenport property alongside on the south side of our property, roll number 7101, they had dug a drainage ditch on their side of the property line, the full length of the two properties. Eventually, within months, it had washed to the north and taken our fence line right out. So Keith Davenport came to me and said, we're going to fill that washout back in, replace your fence. We won't have to worry about any of that anymore. We are tiling that property. The water will be taken care of. They did what they said they were going to do, except for when they went to fill in the washout ditch, they didn't make it all the way back to the east end of the property. They left a slight ditch, I'd say probably 100 meters long, and water flowed in there and then caused a washout into my property. So in the fall of 2021, Davenport started their tile work. Shortly after, within weeks, Mitchell Henry started his tile work. And it wasn't until no one came to me, no one asked me to participate, to accept anybody's water. I assumed they didn't need anything from me. I'd seen the Davenports and Mitchell Henry talking on the side of the road, in the field together, working together. And I'm a kind of a person where I mind my own business. You take care of you, you'll take care of me. In January of 2022, Keith Davenport called me and said, did you know that they have gone down and extended the ditch we didn't get filled in up into the Mitchell Henry property? And now that outlet tile is running down and is going through the washout that our water caused, and it's eroding your property even more. And I said, no, what do we do now? And Keith said, well, you and I need to go talk to them and put a stop to this. So we went that day within 2 hours. In the 2 hours I had, I ran to my computer and I Googled the Tile Drainage Act, so I had a pretty good idea of what I was facing. And I walked into the representative from Marquardt Drainage and Mitchell Henry and Keith Davenport and myself. And I said, we've got to shut this off. Erosion is a big problem on this property. We can't have that water running through an open ditch, through my bush and my pasture, which are keys as well. And the first words I got back from the tile contractor were municipal drain. And I thought, well, that's strange because you have artificially directed water onto my land. Stop it. What does municipal drain have to do with it? They came the next day with a handwritten piece of paper with a sketch of where they would like to run the drain through my property. And I said, again, my biggest problem here is you want to put an open ditch through my pasture land that would run into Waterton Creek, that would run into Georgian Bay, that would run into all the municipal water systems. And we don't need another Walkerton thing happening in our municipality, especially with the technology they have to DNA test manure now, and they could trace that right back to me. They don't seem to understand that. And eventually I said, if you want to bury a tile underground, we can probably work something out if it's a covered tile. The next day, the tile contractor came back again with another sketch in a different location of an open ditch through the middle of the pasture as well. And I said to him, we can't do anything over the top of the land, and I'm not going to make any decisions till you bring me a topographical map outlining the different elevations of the properties, and so we could pick the best route through. I never did receive that. What I received was an agreement, a contract agreement to let them drain water on my property, and it was full of grammatical and spelling errors, and there's no way I'm signing that. And again, he said municipal drain. And then I never heard another thing until I got a phone call from Trevor Kepfer at Burnside that this petition had gone in. I went to the meeting that the petition was presented at to council, asked some questions. This is where we got into the whole, it was new to everybody. No one had any answers. So as we worked through the path, I just kept participating, thinking, I don't like the feeling I'm getting out of this. These guys have come in, they're running rampant on the neighborhood, almost to the theory of we beg forgiveness instead of asking permission. And I didn't want to be associated with this at all, knowing that they had violated common law, as was pointed out earlier, when they artificially directed water onto our property without our permission. So I participated in the public meetings. I didn't have a whole lot to say. Keith Davenport was very adamant that there was a lot of erosion on our properties and we could not go overland. It was his suggestion to go under the ground with a tile through their property, the Waterton Creek. After they had suggested that Mitchell Henry just tie into their tiling that already had an outlet to a municipal drain they put in themselves on the south side of the property. And that was met with resistance by the contractor and Mitchell Henry, and they insisted that I was the answer to their problem and I would solve it for them. So we've gone through the whole process. About a year ago right now, I received a phone call from Trevor Kepfer that they had decided on the part of what you saw here today, which was the underground from Mitchell Henry's through the Davenports, but they wished to do an open ditch from part way up the Mitchell Henry property into my property on roll 7072, go down it and back into the Mitchell Henry property to tie into the catch basin. And I said, no, absolutely not. I've told you there will be no open ditches on our property. Any further communication you have for me, here's my lawyer's contact information, talk to them. I'm done with this. The next day I got another call from Trevor and he said, we've decided the Lipsets are no longer involved. You're just going to have to sign a contract that says you will never try to tie into the municipal drain. I said, absolutely, I can do that. And I never heard another word until in the fall when I got a voicemail from Jeremy, and I ignored it because I'd been informed I was no longer involved. And then I received this package of the engineer's report assessing me $24,720. So as I go through the engineer's report, I see that we're dealing with the erosion on the Mitchell Henry property. That's why we've got to tile it, put the municipal drain in. There was a picture of some of the erosion on the Mitchell Henry property. There was a picture of the ditch that he extended to drain onto my property. But there's no pictures in here of the erosion that this has caused on my property. I have pictures on my phone, if anyone's interested. So then I get this bill, and I had my lawyer call Burnsides for an explanation as to why it was that high. And I now understand it's because they were presented with a problem and here's the solution. They don't get into the backstory. But for me to fill in that washout after they fill in the ditch, I wouldn't have to pay close to $25,000 to do that work. I can repair that washout with my tractor and loader. But under this plan, I'm probably still going to have to fix that washout, but I'm going to have to pay the $24,720. I did take a note earlier when Sid mentioned some properties with direct access to the municipal drain is why they would be assessed that. I don't have direct access to the municipal drain because I can't make water run uphill. So again, I'm totally baffled as to why I was ever dragged into this, except for money, share the cost. So I don't understand how I'm not hosting anything. I'm not doing any tile drainage, but I'm being assessed 15% of the benefit cost for the project. I have a lot of experience farming that land. I'm the 6th generation to farm that land. We've developed practices to avoid erosion. We use perennial crops, as much permanent pasture as we can. We left the bush lot on all those properties on purpose to avoid erosion. And it just seems that this is all going out the window on me. So I'm simply looking at this in the cost benefit, and the property 7101 that's being assessed at $24,720 is listed at 0 affected hectares. But the one that's listed at 1.3 affected hectares, I'm supposed to pay $2,380. So if there's 0 affected hectares, why do I have a bill? So I'm simply seeking answers. I mean, there's a lot of different routes that I could take on this, because I mentioned there were a lot of red flags went up through this whole process. And I don't want to see this turn into a situation where another landowner sees what happened here and they, well, Councillor Bell's my neighbor. I see this as an opportunity to go down and dig a ditch in Councillor Bell's property and then say municipal drain and have him pay for 15% of my project. I don't think that's the precedent we want set in this municipality.
Thank you, Rob. Alex, is it okay if the other panel members have questions for Rob? Yes, Rob to Rob.
Thank you, Mr. Chair. Yeah, thank you for that explanation. Great explanation. In our training, we talked about the validity of a petition having to have 60% of the owners involved required. I'm assuming from what you've said, you didn't sign the petition?
I've signed nothing.
Right. But I'm assuming that the Davenports and Mitchell Henry have.
Only Mitchell Henry.
So theoretically, only one of the 3 participants have actually signed it. So how does it have validity of petition?
Mr. Taylor.
That's
go
That's
ahead.
for me, right? The validity petition is based on the area requiring drainage. We deemed the area requiring drainage was the area that needed an under drainage outlet. Only Mr. Henry's property indicated that they needed under drainage. Mr. Davenport has direct access to Waterson Creek. He has a tile system, so he doesn't sit in the area requiring drainage. Mr. Lipset has indicated that he has access and actually draining channels to the north and the west. Therefore, he's not in the area requiring drainage either. So the difference in area requiring drainage is defined as who needs the drainage and what is the purpose of the petition, and that's what it was. So
We heard earlier this morning that I believe 60% of the ARD would Mr. Henry's property compose 60% or more of the drainage.
of the area requiring drainage, yes.
Yeah, okay,
Yep.
thank you. Deputy Keaveney, do you have?
Just taking it all in.
Okay, fine, thank you. Rob, anything more? Okay, that's fine. Thanks, Mr. Lipset. Number 7 says, are there any other landowners who wish to provide comments today? We don't have anybody virtually or in attendance, so I guess we'll go by that, and no other landowners have posed any questions in writing or okay. Yeah.
I don't think I do, but I guess the last question that hasn't been asked that I should have presented earlier was who should be assessed the cost then? I'm looking at the project and I'm looking at the 1.3 hectares that I've been assessed for, and I'm not going to argue that surface water, although I don't believe it does, because I have a ditching system. I'm not going to argue that small piece. So I suppose my suggestion would be I could absorb the equivalent cost, $2,380 on the second property, given that the erosion repair would be repaired by someone that I wouldn't have to do it. And the rest of the cost, I see no other way to distribute it than to flip it over to Mitchell Henry. He's getting the most of the benefit. The main part of the project is his. I don't see anywhere else to put it. The Davenports have already tiled their land and they've paid. So I can't see any common sense to moving that assessment towards them. The only common sense I see is to put the assessment on the new tile project, which is Mitchell Henry and the municipal drain. The other concern I guess I have is moving forward, when there's any repairs or assessments on the tile drainage, that 15% of the cost comes back to me too. So from here on out, I would be responsible for 15% of the cost of maintenance, repair, removal, reinstallation. And that doesn't make me very comfortable either.
Okay, thanks. Good question. Councillor Jerry?
Thank you, Mr. Chair. Alex, can I ask a question of Mr. Vandry? Welcome back, Sid. Your explanations were great this morning and all the training, and thank you very much for that. So, as in most case law, and you've stipulated very clearly it's statute versus common, so we're not looking at precedent law here, although I will ask. Obviously, this is a case, sounds more like a civil case really than we are tasked with literally adjudicating on the engineer's report, not the prior history of getting to that. Having said that, again, you have some vast experience dealing with Chatham Kent and various other locations. Are there cases that you're aware of where they do delve into cause and effect versus just the engineer report? Or are we literally tasked just with the engineer report?
So your job is to deal with the engineer's report and dealing with assessments under the engineer's report. If the Drainage Act had not been invoked and petitioned for, it would have been a dispute between property owners that could have been resolved through court if anyone decided to take that course of action. The course of action that was chosen was to implement the Drainage Act, and so the task for you. If the Drainage Act wasn't implemented, the municipality would have had no role in this whatsoever. The fact that it's been implemented means that your job is to implement the requirements of the Drainage Act. So deal with assessments as stipulated in the Act, as outlined in the engineer's report and appealed upon.
Thank you.
Thank you, Mr. Chair, and that somewhat answered my question. So I'll just come back then for clarity. You had mentioned at one point during your presentation, Mr. Lepset, that there had been a communication regarding a letter that would, if that had come to you with an opportunity to sign, that would have cleared you from participating in this process whatsoever. So I'm kind of curious what happened with that letter, and you're suggesting you would still like to sign said letter if that option was on the table. Just wanted to clarify what happened to that original letter that you didn't have opportunity to sign.
I never received any more communication from Trevor Kepfer that offered that contract to me, and I never received the contract. I've had really no communication with anybody. I was told that I am happy with how this proceeded when I came to the meeting on January 13th. I had several councilmen and a staff member say to me, well, we were told that everyone's happy and you're ready to go ahead. Well, no one has asked me a question or talked to me in a year. And I was never happy before that. So I don't know where that came from either. So I just have not been afforded the opportunity to present what my problem is when I tried several times with Trevor when he was on the project. And then Jeremy clarified it for me that this is the forum to present my problem, because everyone just kept saying this is not the forum to present that in. So now I'm here. I would gladly sign a form exonerating me from this project altogether. That wouldn't be a problem. But I'm not the type of person to go to court either. I mentioned red flags. There are a lot of things that my legal team and my research have shown that people licenses could be in jeopardy here if I take this too far. I'm not looking to get anybody in trouble for anything. I just want to be left alone. Leave me alone, I'll leave you alone.
Rob, before you leave the podium there, again, a question concerning the property to where, your property, where the drain, is proposed to, dispense. Is it pasture? Is it forest? Is it a mix? Is it cropland?
It's a hundred.
I was up side road 27 yesterday. And when you got snowbanks as high as the ceiling, you couldn't really
Can't
see
see
much
anything.
there. So can you just give me a description of what utilization you have for that property?
It's a square 100 acre property. It's landlocked. There's no access except through other properties that we own. It's about 70 acres of bush, 30 acres of grass that we pasture on. At the north end, the Waterton Creek runs through one corner of it. And that's kind of where we have a fenced off section for cattle to water out of in the summertime, but it's mainly woodlot and pasture. And I have no intention of destroying trees or anything. Some of the proposals I was offered were to take out an acre of bush lot. Not interested in taking out trees either.
Thank you for that. Yes, Deputy Mayor, back to you.
Mr. Chair, thank you. And another question, if I may, for Mr. Vanderveen. I just, again, this being our first opportunity to explore municipal drains, I just want to be clear on the process. So Mr. Lipset has suggested that during the on-site meetings, he expressed objections to what was being proposed. So I just want to understand the legality then of how we got where we are. How then did Mr. Lipset's corner of land still become part of this municipal petition? How did we get here?
Understand, I don't know the specifics, but the engineer, remember I talked about the engineer has a duty to bring the drainage system that's designed to a sufficient outlet. And the engineer, in fulfilling that obligation, can continue the drain downstream through whatever lands are necessary in order to bring it to a sufficient outlet. So the fact that somebody says, I don't want to participate, may have an influence, but it may not as well if it's required to get that sufficient outlet where it's not going to do damage to somebody else. So there are landowners that property owners that ask for things that not always can everything be accommodated. And in a case like this, the engineer has a legal duty to take the drain to a sufficient outlet.
Councilor Urick.
Thank you, Mr. Chair. Before you sit down, Sid. Sorry. I wish the proponent was here. So again, from a purely theoretical basis, the actions that were done originally. So the engineer, I totally respect that what you're doing right now is you're looking at what's the benefits going to be after the fact, based on what is going to be created. Totally get that. What's kind of occurring here and why there's a necessity for this, Mr. Lipset has pointed out that there was damages done prior by water course movement at that point, because he did move the water course. So under the Drainage Act, there was an issue there. I'm not sure this body has the ability or the authority to kind of assign any punitive damages through this by saying, no, you're going to pay the 24 grand because you created the problem in the first place, versus saying, no, we're just looking at the engineering report and based on what's happening, this is the equitability for long-term benefit. That does, notwithstanding, that doesn't change the fact that this has come about because of something he's done in the original. So I don't know whether this engineering report would be the same regardless, presumably if they hadn't done that original work, would the end result have been the same? Or is what they did with the water course originally change things to make this necessity happen now? And if that's the case, like I said, where's the punitive damage to the person that did the initial work that maybe caused this to happen? I know that's not an easy question to answer. But
So I'm just going to deal with the punitive damages and then I'll let the engineer, Jeremy, deal with the question of whether or not it would have been the same. The punitive damages, I think I mentioned during my presentation, the engineer gets appointed for the snapshot in time. The engineer does not act as judge and jury and trying to deal with who's to blame. It's the engineer has to look at the situation as it stands and says who benefits from this using the principles in the act and who's contributing water into it. Those are the two main principles. So as far as, and I don't know how to answer, and this is where I'm going to defer to Jeremy, would it have been different if they had a petition for a municipal drain before they had done any work? Would the assessment have been different? I'm going to defer to you.
I don't think I'll answer a what if scenario because there could be a ton of different what if scenarios as well. I think to be fair, this is the snapshot we have. This is the design that we have. And factoring in what I follow under the Drainage Act of benefit and outlet, deem that there's benefit to downstream lands, whether the landowners think it's benefit or not to them is always a debate. We look at the definition. We think that there is improved control of surface and subsurface water because of this, and therefore the cost, in our opinion, should be split. For the quarter revision, you can either look at that and say, yes, you agree with it, or no, based on the appeal you've heard is saying, I don't think the cost should be the way they're split and take a different route. The assessment of blame, or like Sid just mentioned, the judge and jury, that's not our role. That's not what we look at. We look at where we're at right now. And your other comment, sorry if I may.
go ahead.
You mentioned about having the proponent here. I mean, yes, that would be beneficial. So because if you're starting to think about a change in the assessments, recall from our training that if there is a thought of changing the assessments, to reconvene and give the proponent an opportunity to hear their side as well. So,
Right. Yeah, the problem with, again, statute versus common law and precedent is just, it's interesting because just looking at this as an overall, it would have been really interesting to look at cause and effect to determine how we got here, which has a definite impact on the net result. Hence, I know you can't answer that question because you didn't do the engineering report 2-3 years ago when this was all occurring. But there should, but if there is evidence to the point that Mr. Lipset has that shows that there was actual water course direction at that point, does that not get taken into consideration? Because if there was evidentiary process prior, does that not kind of come before us as well to say, well, cause and effect, we're only at this engineering report because of what happened before? I totally respect that we're looking at the engineering report that's in front of us. Totally respect that. And by the act, I get that. If you're looking at a court scenario, well, you had to get here somehow. And is that not part of the process? Because that strikes me as being odd. If somebody's done something wrong that has changed something and that's not taken into effect, then somebody can be the negative result of something that's beyond their scope of control. And that does seem rather unfair to me. I'm not saying that's an easy question either, but.
As always, there are different arguments to every story. I think the three of us in the Court of Revision have to keep in mind that we're here to make judgment calls on the assessments. And we've got all kinds of hypothetical examples, but that's not really our purpose. So if there's nothing more, Alex, would you like to sum this up? And we're
Thank you, Mr.
Right.
Chair.
Go ahead.
So we're just gonna speak about Court of Revision discussion and deliberation. So in accordance with section 53 of the Drainage Act, the Court of Revision members shall retreat to deliberate appeals and make decisions in private. If the court is considering reducing an assessment and adding it to a property whose owner is not present, the court shall adjourn the Court of Revision and send notice to the absent parties to allow them to appeal the change before reconvening. The Court of Revision may give oral decisions on each appeal and will provide a follow-up decision in writing to the parties. So, Mr. Chair, before the court retreats into the boardroom, earlier this morning, we had a training from Mr. Vanderveen with regards to the Drainage Act and Court of Revision. Should we ask the court if maybe it would be beneficial to have him provide procedural advice in the deliberation process?
Hello, gentlemen. Yeah,
Okay.
I agree.
Okay, thank you. So we will now retreat into the boardroom and we'll return after we deliberate.
I don't want to participate if there's any concerns about my participation.
I've met with you enough, Sid, that I think you could be pretty political when it comes to something like this, so.
I see my role in this as being procedural advice, not
Yeah, I'm okay with you giving guidance,
good. Thank you.
because I think you're the only person in the province that really is qualified yourself.
Yeah, we're live.
That was good, Bill. Okay. Yes, thank you. I'd like to bring this session of the Court of Revision back to order, and after having adjourned for a few minutes, I want to announce that we are considering Mr. Lipsett's appeal. And Mr. Lipsett has directed that a change in assessment where his assessment should be lowered and added to Mr. Henry's assessment. In accordance with Section 53 of the Drainage Act, the court is adjourning and will reconvene to a later date to hear from Mr. Henry. And yes, if there's nothing further, I will call this meeting adjourned. Thank you at 12:31.